Stop! That tree is protected by Municipal Ordinance 47B! I screamed across my lawn, but the chainsaw's mechanical shriek drowned out everything except Deborah Kensington's satisfied smile. The sound hit me first, that bone-deep mechanical scream that pulls you from sleep like a fire alarm, except this alarm was announcing the execution of something irreplaceable. My bedroom windows rattled with each rev of the engine. The digital clock glowed 6:47 a.m. in accusatory red numbers, and outside my window the morning light was filtering through what should have been the familiar comforting canopy of my oak tree. Instead, I watched in horror as chainsaw teeth bit through heartwood that had been growing since before the Civil War. The tree didn't just fall, it was systematically dismembered, branch by ancient branch, while Deborah Kensington stood on my property line with a clipboard pressed against her chest like armor. You're about to hear how one woman's pathological need for control turned a peaceful Tuesday morning into the opening shot of suburban warfare. And let me tell you right now, by the time this story reaches its conclusion, Deborah's gonna wish she never heard the word enforcement. But first, you need to understand how I ended up living in what I now lovingly call Stepford Hell. 6 months earlier, I'd driven through the wrought iron gates of Willowbrook Estates thinking I'd found paradise. The neighborhood was a masterpiece of suburban planning. Tree-lined streets that curved with mathematical precision, Georgian-style homes that looked like they'd been plucked from a Southern Living magazine, and lawns so perfectly manicured they resembled green velvet carpets. Every mailbox was painted the exact same shade of colonial cream. Every driveway was pressure-washed to showroom perfection. Every garden bed was edged with military precision and planted with HOA-approved flora in HOA-approved color schemes. I should have known it was too good to be true when the real estate agent handed me a 47-page community guidelines document before I'd even signed the papers. "Oh, don't worry about all that," she laughed, her bleached smile stretching wide. "It's just standard HOA stuff. Keep your grass cut, don't paint your house purple, you know the drill." What she didn't mention was that Willowbrook Estates wasn't just governed by an HOA, it was ruled by one. And that ruler was Deborah Kensington, a woman who turned neighborhood management into performance art and power into an addiction. My first encounter with Deborah happened exactly 48 hours after I'd moved in. I was kneeling in my front flower bed when a shadow fell across my garden gloves. I looked up to find a woman who appeared to have been carved from suburban perfection itself. Mid-50s, blonde hair that defied both gravity and humidity, wearing a cream-colored blazer that probably cost more than my monthly mortgage payment. Her smile was practiced, professional, and absolutely terrifying. "Welcome to Willowbrook," she said, extending a manicured hand, and I can instantly regret it when her grip lingered a beat too long. "I'm Deborah Kensington, HOA president and your neighbor 3 houses down. I couldn't help but notice you're making some landscaping changes." The way she said changes made it sound like I was planning to install a nuclear reactor in my rose bed. "Just cleaning up the flower beds," I replied, accepting her handshake and immediately regretting it when her grip lingered a beat too long. "Oh, that's wonderful," she beamed. "Of course, any landscaping modifications do need to be submitted to the Architectural Review Committee for approval first. It's all outlined in Section 4.7 of your community guidelines." She produced a folder from seemingly nowhere, thick with forms printed on HOA letterhead. "Just standard procedure, to maintain our property values, you understand." I stared at the forms. There were applications for flower bed modifications, tree pruning requests, lawn ornament permits, and something called a seasonal color palette compliance form. "This is just for pulling up dead flowers?" I asked. "Oh, heavens, no," Deborah laughed, a sound like wind chimes in a tornado. "Dead flower removal is perfectly acceptable under the emergency maintenance clause, but any new plantings, soil amendments, or decorative elements, mulch color, border materials, plant varieties, those all require pre-approval. We've worked very hard to maintain aesthetic consistency throughout Willowbrook." I should have handed the forms back and walked away. Instead, I made the mistake of looking past her toward the oak tree that dominated my front yard. It was magnificent, easily 100 years old, with a trunk so wide 3 people couldn't wrap their arms around it, and branches that stretched across half my property like nature's own architecture. It was the reason I'd bought the house. From my kitchen window, I could see cardinals nesting in its branches. Squirrels had worn highways across its bark. In the evenings, its shadow cooled half my lawn. "The tree is beautiful," I said, almost to myself. Deborah's smile flickered, just for a second, but I caught it. "Yes, well, mature trees do present certain challenges. Liability issues, root damage to foundations, storm hazards. The previous owners received several notices about proper maintenance." "Notices?" "Oh, standard procedure," she said briskly. "Tree health assessments, pruning requirements, that sort of thing. I'm sure you'll want to have it evaluated by a certified arborist soon. We can recommend several HOA-approved services." There was something in her tone that made my attorney instincts prickle. "What kind of notices?" "Oh, nothing urgent," she waved dismissively. "Just routine compliance items. I'll have copies sent over." Her smile returned full force. "Welcome to the neighborhood, dear. I'm sure you'll love it here." She walked away with the confident stride of someone who owned not just her house, but every blade of grass, every fence post, and every resident between Willowbrook's gates. I watched her go, clutching the landscaping forms, and felt the first cold whisper of foreboding. That night, I researched Deborah Kensington online. What I found should have sent me running to the nearest real estate agent. She'd been HOA president for 8 consecutive years, running unopposed in every election. The neighborhood Facebook group read like a testimonial to her iron rule. Post after post of residents seeking permission for minor home improvements, apologizing for violations, asking for guidance on everything from Christmas decoration placement to dog walking schedules. Those who dared question her decisions were met with responses that walked the fine line between helpful and threatening. But it was the local news article from 3 years earlier that made my blood run cold. Willowbrook Estates HOA forces resident to remove memorial garden for deceased child. The story detailed how Deborah had cited Section 12.3 of the Community Guidelines, unauthorized memorial installations, to force a grieving mother to remove a small garden she had planted in memory of her 6-year-old son. The garden had consisted of a single bench and some wildflowers. According to Deborah, the wildflowers were non-conforming plant materials and the bench violated the uniform landscape aesthetic. The family had moved away rather than fight it. I closed my laptop and looked out my kitchen window at the oak tree, its branches swaying gently in the evening breeze. Tomorrow, I decided, I'd call the city planning office to ask about tree protection ordinances. It was probably nothing, but my 15 years practicing property law had taught me that when someone like Deborah Kensington looked at something beautiful and saw a challenge, it was time to start building defenses. I had no idea I was already too late. What I didn't know, what I couldn't have known, was that 3 doors down, Deborah was sitting in her home office reviewing what she called her enforcement files. My file was already 2 inches thick, filled with surveillance photos of my property, violation notices she hadn't sent yet, and a municipal contact list that included 3 different tree removal services. The war for my oak tree had been declared the moment I shook her hand.
Your fence is 3 inches too high, and that rose bush is an unauthorized shade of pink. Those were literally the first words Deborah Kensington ever spoke to me, delivered with the cold precision of a parking ticket while I was still unloading my moving truck. I turned around, expecting to find a city inspector, or maybe a confused neighbor, but instead found myself face to face with suburban authority incarnate. The woman stood on my driveway like she owned it, clipboard clutched against her chest, surveying my property with the calculating eyes of a general planning siege warfare. Her blonde hair was shellacked into submission, despite the August humidity, and her smile could have been carved from ice. You know that feeling when you realize you've accidentally stepped into someone else's nightmare? That was my Tuesday afternoon, watching this perfectly pressed stranger catalog my imaginary violations before I'd even gotten my couch through the front door. The moving truck engine was still ticking with heat behind me, and cardboard boxes were stacked on my lawn like a refugee camp, but Deborah had apparently seen enough to render judgment on my entire existence. "I'm sorry, what?" I managed, setting down the lamp I'd been carrying and wiping sweat from my forehead. "The fence along your east property line," she continued, gesturing with her pen like a conductor directing an orchestra of condemnation. "Current height measures 51 inches. Community guidelines clearly state that decorative fencing cannot exceed 48 inches without written approval from the Architectural Review Committee." She flipped through her binder with the practiced efficiency of someone who'd done this before. "And the climbing rose on your front trellis is what I believe the nurseries call coral sunset. Orange undertones are specifically prohibited under Section 7.2 of our landscaping standards." I stared at her, then at my fence, then back at her. The fence had been there when I'd toured the house 6 times before buying it. The roses had been blooming when I'd signed the papers. "These were here when I bought the house." "Previous owners received multiple notices," she replied, with the tone of someone explaining basic math to a child. "Unfortunately, compliance issues transfer with property ownership. But don't worry, I've taken the liberty of preparing your initial violation summary." She handed me a manila folder thick with papers, all easily rectifiable, of course, assuming prompt attention. I opened the folder and nearly choked. 17 separate violations, each printed on official letterhead and complete with photographic evidence. Apparently, my mailbox was installed 2.3 inches too close to the street, my welcome mat was an unauthorized shade of burgundy, and my front door wreath exceeded the maximum permitted diameter by ½ an inch. "You measured my wreath?" I asked. "Standard protocol during the new resident evaluation," she said, as if measuring decorative foliage was the most normal thing in the world. "I'm Deborah Kensington, by the way, HOA President, Architectural Review Committee Chair, and your neighbor at 4247 Magnolia Drive." She extended her hand with the confidence of someone accustomed to deference. "Welcome to Willowbrook Estates." Here's what you need to understand about neighborhoods like Willowbrook. They don't just happen by accident. Someone, usually someone like Deborah, carefully engineers them into monuments to their own control issues. Every architectural detail, every landscape choice, every decorative element is measured, cataloged, and regulated with the precision of nuclear treaty negotiations. It's suburbia as performance art, with property values as the excuse and power as the real motivation. I should have handed that folder back and told her where she could file her violations. Instead, I made the mistake of trying to be reasonable. "Look, Mrs. Kensington," I began, "I appreciate the thoroughness, but I literally just bought this house. These issues were all here when I signed the papers. Doesn't that count for something?" Her smile widened, and somehow that made it more terrifying. "Previous owner's non-compliance doesn't establish precedent for continued violations. However," she paused dramatically, "the HOA board does recognize the challenges facing new residents. We offer a 90-day grace period for bringing properties into full compliance." 90 days to replace a fence and replant roses? "The grace period applies to minor aesthetic adjustments," she clarified. "Structural modifications like fencing typically require board approval, contractor pre-qualification, and permit coordination with the city. I'd recommend starting the paperwork immediately." I flipped through the folder again, calculating rough costs in my head. The fence alone would run $4,000. The landscaping modifications would add another $2,000. What happens if I don't comply? "Oh, I'm sure that won't be necessary," Deborah said breezily. "Willowbrook residents are wonderfully cooperative. We've built such a lovely community here." She gestured toward the street, where every house looked like it had been assembled from the same catalog, painted in identical colors, and landscaped by the same obsessive-compulsive gardener. "Property values have increased 18% over the past 3 years alone." There was something in the way she said cooperative that made my attorney instincts start buzzing. But hypothetically, well, persistent violations can result in daily fines, of course, standard practice. And eventually, if the issues remain unresolved, the HOA does have the authority to pursue lien placement. She said it casually, like discussing the weather, but I caught the steel underneath. Though, as I said, I'm sure that won't be necessary. I looked around at my new neighborhood, at the perfect lawns and pristine driveways, at the identical mailboxes and regulation-compliant landscaping, and suddenly understood what I was really looking at. This wasn't a community, it was a cult, with Deborah as its perfectly groomed leader and property maintenance as its religion. "I'll need to review these requirements," I said finally. "Of course," she beamed. "Take your time. I've included my direct contact information, as well as the approved contractor list and municipal permit office details. The next Architectural Review Committee meeting is Thursday evening at 7, if you have any questions." She turned to leave, then paused, as if remembering something important. "Oh, and congratulations on the lovely oak tree. Such mature specimens can be challenging to maintain properly, but I'm sure you'll want to have it evaluated soon. Storm season, you know." The way she said challenging made my blood pressure spike, but before I could respond, she was walking away with the confident stride of someone who'd marked her territory. I stood there in my driveway, surrounded by boxes and violation notices, watching Deborah Kensington disappear into her climate-controlled SUV. The folder felt heavier than it should have, weighted with the promise of battles ahead. Around me, Willowbrook Estate stretched in all directions, perfect, pristine, and utterly sterile. That night, after the movers had left and I'd opened my first beer in my new kitchen, I called my old law partner, Jake. "You'll never guess what happened today." I started, but Jake cut me off with a laugh. "HOA problems already? Let me guess, some power-hungry retiree with a measuring tape and a God complex?" "Close," I said. "Power-hungry middle-aged blonde with a measuring tape and a 3-ring binder." "Ah, the professional variety. Those are worse. What's the damage?" I read him some of the violations, and his laughter gradually faded into something more serious. 17 violations on move-in day?" he said. "That's not enforcement, that's harassment. You might want to document everything just in case." "In case of what?" "In case your new neighbor decides you're not worth the trouble of playing nice with." As I hung up the phone and looked out my kitchen window at the oak tree silhouetted against the evening sky, Jake's words echoed in my head. What I didn't know yet was that Deborah Kensington had already decided exactly that, and documentation was going to become the least of my concerns, because 3 doors down, the HOA president was updating her files with a new entry. 4251 Magnolia Drive, non-compliant resident, escalation recommended. The question wasn't whether she'd try to make my life difficult, it was how far she'd be willing to go to win.
This tree is protected by Municipal Ordinance 47B, enacted in 1991, and you are in direct violation of federal environmental protection statutes. The chainsaw operator looked up at me like I'd just spoken ancient Greek, but the panic in Deborah Kensington's eyes told me I'd hit something vital. She clutched her clipboard tighter, her knuckles going white against the beige plastic, and for the first time since I'd met her, that predatory smile faltered. The mechanical shriek of destruction continued behind her,
each rev of the engine driving another nail into what I was beginning to realize might be her professional coffin. You know that moment in every true crime documentary where the perpetrator realizes they've made a fatal mistake? This was that moment, playing out in real time on my front lawn, witnessed by half the neighborhood and documented by the city inspector who just pulled up to the curb. Deborah Kensington had finally overplayed her hand, and the sound you're hearing isn't just a chainsaw, it's the beginning of the end of her 8-year reign of suburban terror. But let me back up and tell you exactly how we got to this point, because the events of the past 6 weeks had been building toward this moment like a legal time bomb. 3 weeks earlier, I'd received what Deborah called a courtesy notice regarding my oak tree. The letter, printed on official HOA letterhead and delivered via certified mail, informed me that my mature deciduous specimen posed multiple safety and maintenance concerns to the community. The language was clinical, almost medical, as if my tree were a patient with a terminal diagnosis, rather than a living monument that had been anchoring this corner lot since before Willowbrook Estates existed. Recent inspection by certified arborist has identified significant risk factors, including, but not limited to, extensive root system potentially compromising neighboring foundation integrity, overhead branch structure exceeding safe clearance parameters for utility lines, and seasonal debris contributing to drainage complications affecting community stormwater management systems. I read that paragraph 5 times before I understood what I was really looking at. This wasn't a safety notice. It was an execution order wrapped in bureaucratic doublespeak. The letter went on to inform me that, pursuant to Section 15.8 of the Community Guidelines, I had 30 days to submit a professional tree removal plan, or the HOA would be compelled to exercise its emergency authority to address imminent safety hazards on behalf of the community. That's when I'd made my first call to the city. Parks and Recreation, Linda speaking. Hi, I'm calling about tree protection ordinances. I live at 4251 Magnolia Drive in Willowbrook Estates, and I need to know if there are any municipal protections for mature oak trees. Hold on, let me check our database. Magnolia Drive, Willowbrook. Okay, I'm showing that entire development area was surveyed in 1991 as part of the Heritage Tree Protection Initiative. What's the approximate diameter of your tree? I'd gone outside with a measuring tape, wrapping it around the giant trunk like I was taking the vital statistics of a giant. Roughly 12 feet in circumference. Oh my, Linda had said, and I could hear papers rustling. That would definitely qualify for protection. Trees with circumferences over 8 feet are automatically enrolled in the Heritage Tree Program under Municipal Ordinance 47B. You should have received notification when you purchased the property. I didn't receive any notification. That's unusual. The ordinance requires disclosure during real estate transactions. I'm going to transfer you to our Code Enforcement Division. Code Enforcement had been even more helpful. Apparently, not only was my tree protected, but any attempt to remove it without a city permit constituted a Class B municipal violation, punishable by fines up to $50,000. Moreover, the Heritage Tree Program specifically superseded HOA authority in cases where community guidelines conflicted with environmental protection ordinances. Your HOA can't touch that tree, not without going through the same permit process as any other entity. And I'll tell you right now, permits for heritage trees are almost never approved unless the tree is genuinely dying or poses an immediate structural threat. Armed with this information, I'd composed what I thought was a reasonable response to Deborah's removal demand. I cited the municipal ordinance, included copies of the heritage tree documentation, and politely requested that the HOA withdraw its removal notice pending proper legal review. Her response had arrived within 48 hours, and it was a masterpiece of passive-aggressive warfare. "Dear homeowner," it began, not even using my name. "Your recent correspondence regarding the mature oak specimen has been reviewed by the Board of Directors and our legal counsel. While we appreciate your concern for neighborhood vegetation, we must respectfully disagree with your interpretation of municipal authority as it relates to private property maintenance within a managed community. The letter went on to explain that HOA covenants, conditions, and restrictions took precedence over city ordinances in matters of property maintenance, and that my continued resistance to reasonable safety measures would result in daily fines of $200 beginning immediately. Furthermore, failure to address this matter within the revised timeline of 7 business days will trigger the emergency removal provision of Section 15.8, authorizing the HOA to contract for immediate tree removal at homeowner expense, with all costs and associated fees added to your annual assessment. I stared at that letter for a long time, feeling something cold and angry settling in my chest. This wasn't about tree safety or community standards. This was about power, pure and simple. Deborah had decided I was a problem, and she was going to make an example of me. That night, I'd called Jake again. "She can't override municipal ordinances," he said immediately. "HOA covenants don't trump environmental protection laws. She's either completely ignorant about legal hierarchy, or she's banking on you backing down before it gets to court. What should I do?" "Document everything. Copy the city on all correspondence, and maybe give the local news a heads up. Illegal tree removal makes great television." The next morning, I'd found the first daily fine notice tucked under my windshield wiper. Notice of violation penalty, $200, oak tree removal noncompliance, day 1. By the end of the week, I had 7 identical notices, each incrementally more threatening than the last. That's when I'd made the call that would change everything. "City Code Enforcement, this is Officer Martinez. I need to report an imminent violation of Municipal Ordinance 47B. My HOA is threatening to remove a protected heritage tree without a permit." "What's the address?" 4251 Magnolia Drive, Willowbrook Estates. "I know that tree," Martinez had said immediately. "Drove by it just last week during routine patrol. Beautiful specimen. When is this supposed to happen?" "They've given me until Friday, but I think they might move faster. The HOA president seems to be escalating things quickly." "I'll put an alert on the property. If anyone shows up with removal equipment, we'll be there within minutes." Which brings us back to Tuesday morning at 6:47 a.m., when the sound of chainsaws had torn me from sleep and sent me stumbling into what would become the opening battle of a war I was finally ready to fight. I stood there in my pajamas, watching Deborah direct the systematic murder of my tree, while Mrs. Henderson sobbed into her bathrobe 3 yards away. The oak's branches were falling like soldiers, each one hitting the ground with a sound that seemed to echo throughout the entire neighborhood. "Stop!" I screamed again, but Deborah just smiled that terrible smile and held up her clipboard like a shield. "Emergency removal authorization," she called back. "Board approved last night by emergency vote." "You can't have an emergency vote without proper notice to homeowners," I shot back, and I saw her smile flicker again. That's when Officer Martinez's patrol car turned the corner, followed immediately by a white van marked City Code Enforcement. Deborah's face went through several interesting color changes as the vehicles pulled into my driveway, but she held her ground with the determination of someone who'd never been challenged and had no intention of starting now. What she didn't realize was that this wasn't just about one tree anymore. This was about every violation notice she'd ever issued, every fine she'd ever collected, and every resident she'd ever bullied into submission. The war for Willowbrook Estates had officially begun, and Deborah Kensington was about to discover that some neighbors fight back.
According to these county soil surveys, your entire foundation is built on contaminated landfill, which means your property value just dropped to approximately $0 and negative cents. The words hung in Deborah's dining room like smoke from a house fire, and I watched 8 years of suburban supremacy crumble in real time across her face. She gripped the edge of her mahogany table, the one she'd purchased with what I now knew were misappropriated HOA landscaping funds, and stared at the environmental assessment report like it might transform into something less devastating if she just concentrated hard enough. The irony was almost too perfect. The woman who'd spent nearly a decade terrorizing neighbors over paint colors and mailbox heights had been sitting on a literal pile of toxic waste, ruling over a kingdom built on poison. You want to know what real investigative work looks like? It's not just about one illegal tree removal. It's about following the money trail until you uncover the entire rotten foundation of someone's carefully constructed empire. But let me take you back 3 weeks, to the morning after Officer Martinez had shut down the chainsaw massacre and issued Deborah her first-ever citation for environmental violations. I'd woken up that morning with something I hadn't felt in months. Hope. Not just the hope of saving my tree, though Martinez had managed that, along with a hefty fine for unauthorized removal attempts, but the hope that comes from finally seeing your opponent's armor crack. Deborah's panicked expression when the code enforcement van pulled up told me everything I needed to know. She wasn't invincible, and she definitely wasn't as legally bulletproof as she pretended to be. That's when I'd decided to stop playing defense and start playing detective. My first stop was the county courthouse, where property records are public and secrets go to die. I'd spent 15 years as a property attorney, which meant I knew exactly where to look and what questions to ask. The clerk, a cheerful woman named Betty, who'd apparently been watching HOA drama unfold for decades, was more helpful than I'd expected. "Willowbrook Estates," she'd said, pulling out a thick file. "Oh, honey, you picked a doozy. That development's been in and out of here more times than a revolving door. What are you looking for specifically?" "Everything," I'd told her. "Property transfers, permit applications, environmental assessments, zoning variances, anything with Deborah Kensington's name on it." Betty's eyebrows had climbed toward her hairline. "The HOA president? Lord, that woman's been a thorn in the planning department's side for years. Always trying to get special exceptions for her friends, always fighting when we deny them." She'd leaned closer conspiratorially. "Between you and me, we've been wondering when someone would start asking the right questions." The first document she pulled changed everything. A zoning variance application from 2019 requesting permission to build a detached garage that exceeded height restrictions. The application had been denied by the Planning Commission, but according to the aerial photos Betty showed me, the garage had been built anyway. "That's Deborah's address," I noted, pointing to the application. "Sure is," Betty had confirmed, "and that's not the only unapproved construction we've got flagged at that address. There's also a deck extension from 2021 and a pool house from last year, all built without permits, all in violation of setback requirements." I thought that familiar tingle of a case coming together. What's the penalty for unpermitted construction? Depends on the scope, but we're talking potential fines in the tens of thousands, plus mandatory teardown orders if the structures can't be brought into compliance. The second document had been even more interesting. Financial records showing that Willowbrook HOA had paid over $40,000 to Kensington Construction Services over the past 2 years. "That's her husband's company," Betty had explained. "Been getting a lot of HOA maintenance contracts lately. Pool graining, landscaping, general repairs. Always seems to win the bids even when other companies submit lower estimates." I spent the next 4 hours copying documents, cross-referencing addresses, and building what any prosecutor would recognize as a compelling case for fraud, embezzlement, and abuse of authority. But the bombshell came when Betty pulled out the environmental assessment file. "This one just came in last month," she had said, handing me a thick report with "Urgent Environmental Hazard" stamped across the cover in red ink. "County finally got around to testing that whole area after some contamination showed up in the groundwater downstream." The report was damning. The entire southwestern section of Willowbrook Estates, including Deborah's property, had been built on a former industrial dump site that hadn't been properly remediated. Soil samples showed elevated levels of heavy metals, chemical solvents, and other toxins that made the area unsuitable for residential development. "What does this mean for the homeowners?" I asked. "Nothing good," she had replied grimly.
Property values in contaminated zones typically drop to near zero. Insurance companies won't cover environmental hazards, and banks won't approve mortgages on contaminated land. Plus, the county's looking at mandatory soil remediation, which could cost each homeowner upwards of $200,000. I stared at the map showing the contamination zone, watching it overlay perfectly with the most expensive properties in Willowbrook, including the house where Deborah had been ruling her suburban empire for 8 years. That afternoon, I'd made a decision that would have made my law partners proud and my mother terrified. I'd knocked on Deborah's door. She'd answered wearing her usual armor of pressed clothing and practiced smile, but I'd caught the flicker of uncertainty in her eyes when she saw the folder in my hands. "We need to talk," I'd said simply. 20 minutes later, we were sitting in her dining room, the same room where she probably plotted hundreds of violation notices and fine assessments, and I was watching her world collapse, one document at a time. "These are all public records," I'd explained, spreading the papers across her table like evidence at a crime scene. "Building permits that were denied but apparently ignored, HOA funds paid to your husband's company for work that should have gone through competitive bidding, and this," I'd placed the environmental report in front of her, "is your county's official assessment of what your property is actually worth." Deborah's face went through several interesting color changes as she processed the documents. When she finally spoke, her voice had none of its usual authority. "What do you want?" "I want you to resign. I want you to return the money you have stolen from the HOA, and I want you to stop harassing residents over minor violations while you're sitting on major ones yourself." "You can't prove any of this," she said, but there was no conviction behind the words. "Can't I?" I pulled out my phone and showed her the photos I'd taken of her unpermitted structures. "Your garage is 3 feet too tall and 5 feet too close to your property line. Your pool house was built without environmental impact assessment on contaminated soil. And these financial records show clear patterns of self-dealing that would make any forensic accountant very, very interested." The silence that followed was only broken by the tick of her grandfather clock, another unauthorized addition according to the architectural guidelines she'd written herself. "What happens if I don't?" she finally asked. "Then I file a complaint with the State Attorney General's office for HOA fraud, a complaint with the county for permit violations, and a lawsuit on behalf of every resident who's been fined or harassed while you've been running your personal money laundering operation." I'd gathered my papers and stood to leave, but paused at her front door. "Oh, and Deborah, you might want to call your insurance company about that contaminated soil situation. I have a feeling they're going to have some very interesting questions about your coverage." As I walked home past her perfectly manicured lawn and regulation-compliant landscaping, I felt something shift in the neighborhood's atmosphere. The balance of power that had seemed so unshakable just weeks earlier was beginning to crumble, one exposed secret at a time. But what I didn't know yet was that Deborah Kensington wasn't the type to go quietly into retirement. If anything, cornering her was about to make her more dangerous than ever, and the next phase of our suburban war was going to make everything that had come before look like a polite disagreement over fence heights.
Mrs. Kensington, you're being served with a federal subpoena for financial records, a state civil suit for breach of fiduciary duty, and a criminal summons for embezzlement in the first degree. The process server's words carried across the morning air like a death knell for suburban tyranny, and I had to set down my coffee mug to keep from spilling it while I savored the moment. Deborah stood in her doorway clutching her silk bathrobe like armor, her usually perfect hair resembling something from a horror movie, staring at the mountain of legal papers like they might spontaneously combust if she willed it hard enough. This was the woman who terrorized an entire neighborhood with measuring tapes and violation notices, reduced to a disheveled mess at 7 in the morning because karma had finally decided to audit her books. The beautiful irony wasn't lost on me. After years of delivering unwanted paperwork to residents' doorsteps, Deborah was finally getting some special delivery mail of her own. But what you're about to hear isn't just about one woman's legal troubles. It's about how an entire community discovered that fighting back against petty tyranny requires more than just individual courage. 2 weeks had passed since my confrontation in Deborah's dining room, and I'd spent every one of those days building what Jake called the most beautiful legal demolition he'd seen in 20 years of practice. But this wasn't just about personal revenge anymore. It was about systematic justice. The morning after I'd laid out the evidence for Deborah, she'd made her first mistake. Instead of quietly resigning and hoping the whole thing would blow over, she doubled down. I'd woken up to find a certified letter from Kensington & Associates Legal Services. Apparently her husband had decided to cosplay as a lawyer now, demanding that I cease and desist from what they called harassment and defamation of an elected community official. The letter was a masterpiece of amateur legal writing, complete with misquoted statutes and threats that would have made any first-year law student laugh. But it was also evidence of conspiracy, which Jake had pointed out while nearly choking on his coffee. She's trying to use fake legal intimidation to cover up real crimes, he'd explained. That's not just fraud anymore, that's obstruction of justice. That same afternoon, Deborah had made her second mistake. She'd called an emergency HOA board meeting and attempted to have me declared a disruptive resident, subject to immediate fine escalation and possible litigation for continued violations of community standards. What she didn't know was that 3 of the 7 board members had been secretly documenting her financial irregularities for months, waiting for someone with legal expertise to help them take action. Mrs. Patterson from Elm Street had been keeping copies of every suspicious expenditure since 2021. Mr. Rodriguez from Oak Lane had been photographing the unpermitted construction around the neighborhood. And Carol Hendricks, sweet elderly Carol who brought cookies to every meeting, had been recording every board session on her smartphone because, as she'd explained with a perfectly innocent smile, at my age, memory isn't what it used to be. The emergency meeting had turned into an emergency coup. "I call for a vote of no confidence," Mrs. Patterson had announced, standing up with a folder thick enough to stop a bullet. "I have documentation showing that our president has approved over $150,000 in questionable expenditures over the past 3 years, including payments to her husband's company for work that was never competitively bid." The motion had passed 5-2, with only Deborah and her closest ally, a woman named Margaret who'd apparently been getting cut-rate landscaping in exchange for her loyalty, voting against it. But Deborah's third and most catastrophic mistake had come the next morning when she'd attempted to use her still active HOA bank access to transfer what was left of the community maintenance fund into her personal account. She'd clearly expected to be able to grab the money and disappear before anyone noticed, but modern banking has digital footprints, and electronic theft leaves electronic evidence. The bank's fraud detection system had flagged the transfer within minutes, freezing both accounts and triggering an automatic notification to local law enforcement. That's when I made the call that would change everything. FBI Financial Crimes Unit Agent Sarah Chen speaking. "I need to report ongoing embezzlement and fraud within a homeowners association that appears to involve federal banking violations." Agent Chen had been surprisingly interested, especially when I'd mentioned the environmental contamination angle and the potential for federal environmental crimes. Apparently, the FBI takes a very dim view of people who build housing developments on contaminated land without proper disclosure to buyers. "How much money are we talking about?" she asked. "Conservative estimate? $300,000 in direct theft, plus another $2 million in property damage from the environmental issues that were never properly disclosed. I can have a team there tomorrow." Which brings us back to that beautiful morning when the process server's knock had echoed through Willowbrook like a starting pistol for justice. I'd watched from my kitchen window as Deborah signed for her legal papers, her hands shaking so badly she could barely hold the pen. The process server had been thorough, federal subpoena, state civil suit for breach of fiduciary duty, and a criminal summons for embezzlement in the first degree. But the real fireworks had started an hour later when 3 black SUVs had pulled up to Deborah's house and 8 FBI agents had walked up her perfectly manicured driveway carrying boxes of evidence bags and search warrants. I'd made myself a fresh pot of coffee and settled in to watch federal law enforcement systematically dismantle 8 years of suburban corruption. They'd spent 6 hours in Deborah's house, loading computers, filing cabinets, and financial records into their vehicles, while half the neighborhood gathered on sidewalks to watch the show. Mrs. Henderson had brought popcorn. But the best part, the part that still makes me smile when I think about it, was watching Deborah try to maintain her dignity while her world collapsed around her. She'd emerged from her house in what I can only describe as crisis Karen attire. A wrinkled blazer over pajama pants, hair that defied several laws of physics, and the kind of wild-eyed expression you see in mugshots. "This is all a misunderstanding," she announced to the growing crowd of neighbors, her voice cracking like thin ice. "I've done nothing but serve this community faithfully for 8 years. These are baseless accusations from a disgruntled resident who has been violating community standards since the day he moved in." That's when Agent Chen had stepped forward with the kind of smile that prosecutors dream about. "Ma'am, you have the right to remain silent. I suggest using it." The handcuffs had made a satisfying clicking sound as they closed around Deborah's wrists, and I felt something shift in the neighborhood's atmosphere, like pressure releasing from a kettle that had been building steam for years. Over the next week, the full scope of Deborah's crimes emerged in a series of news reports that made national headlines. The embezzlement charges alone carried potential sentences of 10 to 15 years. The environmental fraud could add another decade. And the federal banking violations were what Jake cheerfully called the cherry on top of a very expensive legal sundae. But the real victory wasn't Deborah's arrest. It was what happened next. 43 residents had joined the class action suit seeking damages for years of harassment and illegal fines. The state attorney general had opened an investigation into HOA practices statewide, and the EPA had begun a comprehensive environmental assessment that would finally force proper remediation of the contaminated properties. As I sat on my front porch that evening, looking out at my oak tree's new growth in the fading light, I realized that this had never really been about one tree or one woman's power trip. It had been about something much more fundamental, the right to live in peace without being terrorized by petty authoritarians who mistake a clipboard for a crown. But even with Deborah in custody and her empire crumbling, I couldn't shake the feeling that this story wasn't over. Federal investigations take time, trials can drag on for years, and sometimes the most dangerous moments come after you think you've already won. What I didn't know was that Deborah Kensington had one final card to play, and she was about to make a move that would risk everything, including the very house she'd used as the symbol of her suburban supremacy.
Your Honor, I hereby transfer ownership of 4247 Magnolia Drive to the plaintiff as full compensation for damages, environmental remediation costs, and punitive awards totaling $847,000. The gavel's crack echoed through the courtroom like thunder, officially ending Deborah Kensington's 8-year reign of suburban terror and beginning the most satisfying chapter of my life. I sat in that judge's chambers, holding legal documents that would have seemed impossible 2 years earlier, papers that literally transferred Deborah's dream house into my name as payment for her crimes against trees, neighbors, and basic human decency. The woman who'd once measured my welcome mat with a ruler was now legally required to hand over the keys to her McMansion, complete with the illegal garage, unpermitted pool house, and contaminated soil that had made her property worth less than the legal fees she owed. You want to know what justice looks like? It's watching someone who built their identity on controlling other people's property lose their own property to the very person they tried to control. But let me take you back to how we got from federal arrest to property transfer. because the path from handcuffs to house keys was more twisted than any HOA bylaw Deborah had ever written. 18 months had passed since the FBI had carried boxes of evidence out of Deborah's house, and those months had been a masterclass in watching someone's life unravel one thread at a time. The federal embezzlement charges had been the headline grabber, but it was the civil litigation that had delivered the real satisfaction. My attorney, not Jake anymore, but a specialist in HOA law named Patricia Hendricks, who had the reputation for dismantling corrupt homeowners associations like she was defusing bombs, had approached the case with surgical precision. "We're not just seeking damages," she'd explained during our first strategy meeting. "We're seeking to completely restructure the power dynamic in this community. Deborah didn't just steal money, she stole people's peace of mind, their property rights, and their sense of home." The civil suit had been a thing of beauty. Patricia had filed claims for harassment, intentional infliction of emotional distress, violation of property rights, conspiracy to defraud, breach of fiduciary duty, and about 15 other causes of action that made Deborah's legal team look like they'd been hit by a freight train made of statute books. But the real genius had been Patricia's decision to pursue what's called equitable relief, essentially asking the court to fix the situation by any means necessary, including property transfer if monetary damages weren't sufficient. "Your client destroyed a heritage tree worth approximately $50,000, but that tree was irreplaceable. No amount of money can restore a 100-year-old oak. However, transferring the defendant's property would provide both compensation and ensure that this kind of abuse never happens again." Deborah's legal team had fought the property transfer demand like their lives depended on it, which in a way they did. Losing the house would mean Deborah couldn't afford to continue paying legal fees, which meant her attorneys would abandon ship faster than rats fleeing a sinking yacht. The environmental contamination evidence had been devastating to their defense. Not only had Deborah known about the soil problems, the EPA investigation had turned up emails where she'd actively worked to suppress environmental testing that might have revealed the contamination and hurt property values. She prioritized her position and property values over the health and safety of her neighbors, Patricia had told the jury during closing arguments. "This isn't just about HOA overreach. This is about someone who is willing to let families live on contaminated land rather than admit she'd made mistakes." The criminal trial had wrapped up first, with Deborah pleading guilty to federal embezzlement charges and receiving a sentence of 4 years in federal prison, followed by 5 years of probation. The judge had been particularly harsh about the environmental cover-up, noting that public officials, even volunteer ones, have a responsibility to protect their communities, not exploit them. But it was the civil trial that had delivered the real fireworks. Patricia had called 47 witnesses, every resident who'd been harassed, fined, or intimidated over the years. Mrs. Henderson had testified about being fined for hanging laundry on a clothesline during a heat wave when her air conditioner broke. Mr. Rodriguez had described being threatened with liens for parking his work truck in his own driveway. Carol Hendricks, no relation to my attorney despite the shared name, had brought the jury to tears describing how Deborah had forced her to remove a memorial garden for her deceased grandson. When it came time for Deborah to testify in her own defense, she'd made the mistake of trying to maintain her authority even from the witness stand. "I was protecting property values," she'd insisted, her voice carrying the same imperious tone that had terrorized the neighborhood for years. "Visual violation I cited was legitimate. Every fine I assessed was justified under our community guidelines." Patricia had been ready for that. "Mrs. Kensington, you cited my client for having rose bushes that were the wrong color. At the same time, you were using HOA funds to renovate your own home. Do you see the hypocrisy in that?" "Those were approved maintenance expenditures," she'd replied, but her voice cracked slightly. "Approved by whom? You were the board president, the architectural committee chair, and the financial oversight officer. You literally approved your own expense reports." The jury had deliberated for less than 3 hours before returning a verdict that made local legal history. $847,000 in compensatory and punitive damages with the unique remedy of property transfer to satisfy the judgment. Judge Morrison had been almost philosophical in his ruling. This case represents a fundamental abuse of trust that goes to the heart of community living. The defendant used her position to enrich herself while terrorizing the very people she was supposed to serve. Traditional monetary damages would be insufficient to address the scope of harm caused. Property transfer serves both as appropriate compensation and as a deterrent to others who might abuse community leadership positions. That had been 6 months ago. Since then, I'd watched Deborah navigate bankruptcy proceedings, divorce filings. Apparently, her husband had decided that being married to a federal felon wasn't good for his construction business, and the slow, grinding process of losing everything she'd built her identity around. The day she'd been required to turn over the house keys was surreal. I arrived at the property at exactly 10 a.m., as specified in the court order, to find Deborah loading boxes into a U-Haul truck parked in the driveway where she'd once stood with her clipboard cataloging my imaginary violations. She looked smaller somehow, diminished by the weight of consequences she never imagined could touch her. Gone was the pressed blazer and perfect hair. In their place was a woman in jeans and a faded t-shirt who looked like she hadn't slept in months. "The keys are on the kitchen counter," she'd said without looking at me, her voice barely above a whisper. "The utilities have been transferred to your name as of yesterday." I walked through the house she'd built with stolen HOA funds, noting the irony of every illegal modification she'd made while citing other residents for minor infractions. The garage that exceeded height restrictions, the deck that violated setback requirements, the pool house built without permits on contaminated soil. In her home office, I found something that made me smile. A filing cabinet full of violation notices she'd never sent, complaints she'd prepared but never filed, and surveillance photos of neighbors she had been watching for years. The woman had turned paranoia into a filing system. But it was in her garden where I found the perfect final touch. Rich, dark topsoil that had been brought in to cover the contaminated earth beneath. Soil that would be perfect for planting a new oak tree. That afternoon, I drove to the local nursery and selected a young oak sapling, maybe 3 feet tall, with the kind of strong root system that suggested it would grow into something magnificent given time and proper care. As I planted it in my front yard, not the former Deborah property, but my original home where this whole saga had begun, I used soil from her garden to give it the best possible start. There was something beautifully cyclical about using earth from the house she'd lost to nurture new growth in the place where she had tried to destroy it. Mrs. Henderson had come over to watch the planting, bringing lemonade and the kind of satisfied smile that comes from seeing justice finally served. "Think it'll grow as big as the old one?" she asked, shading her eyes against the afternoon sun. "Maybe," I replied, patting the soil around the sapling's base. "But even if it doesn't, it'll grow up in a neighborhood where no one can cut it down without permission." As I write this, that little oak is showing its first new leaves of spring, reaching towards a sky that's free of chainsaw threats and violation notices. Deborah Kensington is 18 months into her federal sentence, banned permanently from serving on any Homeowners Association board, and living in government housing that probably has its own very strict rules about tree maintenance. And me? I'm the proud owner of 2 houses in Willowbrook Estates, the chair of our newly reformed HOA, which operates on principles of transparency and actual community service, and the guardian of what will someday become another century-old oak tree. Sometimes justice isn't just about winning.